Ladies and gentlemen, and welcome to the 16th lecture in this series. I'm pleased to see that so many of you signed up, but of course very disappointed that yet again we're all meeting virtually. But I'll say it again, hopefully by next year we'll all be able to be, or some of us will be in the same room. I'd like to begin by thanking HKIAC for arranging everything, and of course to BICL, British Institute for International Comparative Law, for their continued sponsorship of this lecture series. Now, in the past, we've had several lecturers who were retired judges who have found a second career in arbitration, thus nullifying the statutory age of senility. But each of them was a state court judge. So tonight, as another first in this series, we have a very recently retired judge from a pan-European court. Our lecturer tonight, Robert Spano, has completed his 9-year term on the European Court of Human Rights, the last 2 years as its president, and is thus obliged to retire, and has retired a few days ago at the tender age of 50. Robert is Icelandic, and that's another first for this series. He's had a very distinguished career. After studying law and completing his studies at Oxford, he served as a deputy judge and then was the Icelandic parliamentary ombudsman. He's been appointed as an ad hoc judge on an EFTA case, and he's been dean of the law faculty at Iceland University. His time on the European Court of Human Rights has seen much transformation, which he's helped lead. The court is extremely busy, as you can imagine, and with well over 30 judges, I think, it needs a lot of managing. At the beginning of next year, he will join as counsel the US law firm of Gibson, Dunn & Crusher, where he will be involved in international arbitration, digital rights, and of course, advising on human rights issues. His theme tonight examines whether there's any scope to use in investment arbitration, a doctrine which has been used and commented upon quite extensively in human rights law. Let me just say this, that if you have any questions, please put them on the chat option, and Robert, I know, will be pleased to answer them at the end of the lecture. So it's my very great pleasure to invite Robert Spano to deliver this year's lecture. Robert.
Thank you very much indeed, Neil, and to the organizers for inviting me to give the 2022 Kaplan Lecture. It's a great honor and indeed a great pleasure. I want to begin by sort of making quite a provocative claim, which is that investor-state arbitration is at the cusp of a new era. A new frontier may have to be traversed in which arbitral tribunals will increasingly have to reconcile conflicting interests of the protected investor on the one hand, and the public interest invoked by national authorities in the host state on the other. Now, there is, of course, nothing as such new to this particular claim. Balancing has been an integral part of investor-state cases over the years. Indeed, as the current Secretary General of ICSID, Meg Kinnear, recently quoted, "From the beginning, there has been a clear commitment in the ICSID system to balancing the interests of investors and host states." So why am I now making this claim? Why potentially a new frontier? And my answer is this: the global order of investment and trade does not and has never operated in a vacuum. We live in an age of increased uncertainty and upheaval. Governments are increasingly having to react to internal and external regulatory pressures triggered by conflict, resulting, for example, recently in an energy crisis and natural phenomena like the COVID-19 pandemic and climate change. We, of course, see all of this in some ways manifested in the debate on the future of the Energy Charter Treaty, where we see states even withdrawing on the basis that public policy considerations, their need to deal with climate change issues may have an impact on their willingness to continue within the Energy Charter Treaty system. This is a manifestation of what we're dealing with at the moment. So what I wanted to do in this lecture, because it is clear that this interplay between investor protections and the public interest is one which arbitrators and counsel will have to be cognizant of, even more so in the age we are moving into. I would like in this lecture to focus on the legal articulation of the space for maneuver, the regulatory space, often termed the state's police powers in investment treaty law, that dispute resolution mechanisms at international level are often asked to grant national authorities in fulfilling their obligations under international treaties. Now, in determining the scope and contours of the state's regulatory space, international courts and arbitral tribunals have sometimes employed formulations such as margin of discretion, a margin of deference, or utilized an umbrella concept, which I will call the doctrine of the margin of appreciation. And we see that, and I will mention some of these arbitral awards later in the lecture. Now, what does the margin of appreciation mean in this context? Now, one can say it encompasses a framework of analysis for standards of review when states use their regulatory powers to restrict or limit rights of individuals or legal persons guaranteed under international treaties or as provided for by customary norms of public international law. Interestingly, in the last decade or so, and we at the Strasbourg Court have been very much a part of that debate, much academic ink has been spilt on whether the margin of appreciation applies at all in investor-state arbitration, as well as arbitrators themselves wielding their pens on this issue. Forceful arguments have been adduced for and against an affirmative answer. Now, in the lecture, I will reflect on this debate, and I will pose the question whether traversing this new frontier in international investment law can succeed if a black and white approach is adopted. Some have claimed that arguments can be adduced in favor of a middle ground, which accepts as a methodological starting point that the conceptual core of the doctrine of the margin of appreciation can potentially inform the operation of review in investor-state cases. Now, without perhaps taking any firm position myself in this lecture, I would wish to explore this claim by drawing on the operation of the doctrine as it has been applied in cases brought under the European Convention on Human Rights. I will sometimes abbreviate the ECHR, and decided by the European Court of Human Rights, where I had the honor to serve as a judge for 9 years, as just mentioned by Neil, and as its president for the last 2.5 years. I will proceed in 3 parts. First, I would wish to discuss whether the doctrine of the margin of appreciation is at all fit for purpose in investor-state cases. Now, that's the question of principle, the principle starting point. Now, as I will explain, in my view, the margin of appreciation seems not as such to be applicable in all of its essential elements without the doctrine or a similar standard of review being reasonably adduced from the text or overall structure of a bilateral or multilateral investment treaty. I mean, ultimately, the 4 corners of the treaty in question indeed limit and constrain the interpretive process so as to conform to the object and purpose of such treaties. But in the second part, I will potentially explore, and I would wish to explore those claims that some have made, that it may be helpful to have regard to the core conceptual elements of the doctrine in certain cases. By this argument, it has been submitted by commentators that the doctrine may assist in developing a consistent and coherent conceptual framework in formulating standards of review in investor-state cases when tribunal review of host state action is indeed required. But here, this is the important point, required by the text, object, or purpose of the relevant treaty provision itself. Investor protections would, it is often claimed, actually be strengthened at the level of foreseeability and substance, whilst at the same time informing further the scope and content of the regulatory space left to the states under the police powers doctrine. Now, this is the crux of the fundamental debate in ISDS at the moment. In this manner, the argument is made that the complete disregard of the margin of appreciation in investment treaty law, which some have argued, very prominent arbitrators have argued, may in fact weaken investor protections, not the inverse. This is a counterintuitive claim, as well as create uncertainty as to the commitments entered into by the host state. On this basis, and as I want to elaborate in my third and final part, the correct question to ask in a particular investor state case is then what objectively should be the level of intensity of review applied to the particular facts, taking account of the special characteristics and purposes of investment treaties. And I think, of course, here in the provision in question implicated, and whether the doctrine of the margin of appreciation can at all assist in that assessment. And I will, in this final part, draw some conclusions from existing arbitral practice in the investor state field. So in sum, what I will attempt to do, to the best of my abilities, and this is my contribution, explore the arguments for and against the reliance on the doctrine of the margin of appreciation in investor state arbitration. In particular, whether a possible middle ground is at all realistic between those that fully embrace the doctrine as a viable method of analysis in investor state cases, and those that fully reject its application as irrelevant or illegitimate, as has been argued. Now, having just stepped down from my role as president of the European Court of Human Rights and entering private practice within the investor state field, I hope that I can in this manner contribute to a modest extent to this very interesting and important debate on standards of review in investor state arbitration. Now, to my first part, and what I want to do is sketch the manner in which review of government action under the ECHR operates and the functional similarities and normative differences with review under bilateral or multilateral investment treaties. When it comes to adjudication in the Strasbourg Court on the one hand and before investor state tribunals on the other, one should not overlook the similarities and complementarities viewed functionally between the two regimes, as others have correctly identified. Both regimes empower individuals to bring suit against states directly before an international dispute resolution mechanism over alleged violations of treaty rights. Moreover, both under the European Convention and its property rights provision of Article 1 of Protocol 1, and under investment treaties, property rights protection is central. The juridical relationship forming the basis of the adjudication is the same in cases under the ECHR as under investment treaties. In other words, in both situations, a private actor files a claim against a sovereign state before an international dispute resolution mechanism, having the power to issue legally binding decisions on whether the state has contravened an international norm regulating the boundaries of legitimate public actions or omissions. The nature of the adjudicative review process is also similar when it comes to the gravamen of the legal issues to be resolved. But this is as far as the similarities go for the following four reasons. Now, firstly, the margin of appreciation, which is of course most famously developed by the Strasbourg Court, is constructed on the basis of certain fundamental structural features of the convention system. For example, the requirement of the non-exhaustion of domestic remedies. And I put aside now the fact that under Article 26 of the ICSID Convention, states can require exhaustion of domestic remedies, because this, I think, is an integral part of the Strasbourg system requiring, to some extent, the second point that I want to make is that the margin of appreciation is primarily applicable when it comes to rights and freedoms under the convention, which are textually couched in qualitative terms, thus providing for exceptions which refer directly to governmental measures being necessary in a democratic society. Or when it comes to property rights cases, this is the wording of Article 1, Paragraph 2 of Protocol number 1, necessary to control the use of property. So the necessity prong of the convention dealing with measures is textually infused in the system, and of course requires that domestic authorities to make the initial assessments subject to Strasbourg Court European supervision. The third point that I would make is that whilst the margin, which has been developed for decades in Strasbourg, has been without any textually explicit basis in the convention. And I think this is important for those that argue, well, the margin of appreciation is never textually formulated in BITs or MITs, or indeed in any investment treaties. But I would say, I think that applies to most other standards of review. You will not usually find them textually couched in the investment treaties. But as of 1st August 2021, this doctrine has now been inserted into the preamble to the European Convention. So actually, its normative legitimacy within the convention system has now been manifest. My fourth and final point is I think it should be important to be cognizant of the fact that the formulation of the right to property under Article 1 of Protocol 1 to the Convention is not, when it comes to its conceptual force and strength, necessarily similar to the more significant weight ascribed to investor rights under both bilateral or multilateral investment treaties. And this is, of course, what the underlying argument now, the debate about the Energy Charter Treaty is, of course, this argument that investment treaties are inherently conceptually structured around focusing on protecting investor rights. It has been argued by some commentators that the text of Article 1 of Protocol 1 itself shows that there is greater scope for state interference with property rights than other convention rights. Now, having been a judge for 9 years in the Strasbourg Court, I think this argument needs to be qualified. I will revert to this in a bit more detail in a moment. It's not necessarily the case that the intensity of review in a particular case under Article 1 of Protocol 1 will ultimately be considered less strict on the facts than review under investment treaties. I think this is often it's a myth that is often perpetuated in this field. Several important elements may in fact lead to the opposite conclusion, and I will talk about that in a moment. But in sum, for these reasons, I think one has to proceed in investor-state arbitration on the basis that the ECHR doctrine of the margin of appreciation cannot as such be transposed wholesale to the investor-state field. I think this is an important methodological starting point. It precludes the automatic application of the margin of appreciation in investor-state cases without the investment treaty in question forming as such an entry point due to the way the text or purpose of the treaty provision implicated so allows. So it's not like it permeates like an umbrella in investment treaty law. It actually forms potentially in cases an entry through the investment treaty in question. And that I think has to be the starting point. In proceeding further, it is necessary to reflect on the arguments for and against on a different level for the use of the margin of appreciation in investment treaty cases under public international law, and then examine potentially relevant policy arguments. Now, if you first turn to public international law, it has been argued that the margin of appreciation has no basis in customary international law. Therefore, it has been claimed that reliance on the doctrine, whether by drawing inspiration from the ECHR doctrine or other sources of international law, is inapposite. There is also an example, a very clear statement in the 2007 award in Siemens versus Argentina of a tribunal opining, and I quote, that the European Convention on Human Rights permits a margin of appreciation not found in customary international law. Now, allow me to leave aside the question whether it is correct as a matter of the current state of public international law that the margin cannot be considered an existing norm. I think this is an issue that requires extensive reflection. For the time being, the salient question in my view is whether the margin of appreciation as a standard of review of states' regulatory actions or omissions must be considered a fixed binding rule or legal principle, thus requiring a clear normative basis in public international law, so as to permit arbitral tribunals to make use of it in their awards without a clear textual mandate in the investment treaty in question. The question is this the nature of the margin of appreciation? That, in other words, one has to inquire and come to a conclusion on its fixed normative existence in public international law before it can be justified to extrapolate from it in the interpretation and application of investment treaties. At the outset, I note there are several examples in recent awards of tribunals referring to a margin of appreciation, sometimes using wording like a margin of discretion or margin of deference in their findings. From these awards, which I will refer to in a moment, it seems to transpire that some arbitral tribunals have considered that sometimes the threshold question to answer in a particular investor state case is whether the text, object, and purpose of the respective investment treaty in play inherently requires the arbitral tribunal seized of the matter to apply a standard of review when examining states' regulatory policy decisions impacting investor protections. For example, under FETs, fair and equitable treatment provision, most favored nation provisions, obligations of national treatment, or indeed essential security provisions. Within this context, tribunals seem to have considered that it is open to them to seek inspiration from other fields of international law. Now, the way I read these awards is that they suggest that the issue in question is then one of applying a methodological framework of analysis related to standards of review by an international dispute resolution mechanism with competence to review state action. Now, at the more doctrinal level, allow me moreover to note the following. The principle of systemic integration, which is very much referred to in investor state practice, seems to support this approach. Now, the best award that I can think of when it comes to applying this principle within this context is the award in Urbasser versus Argentina of 2016, where the tribunal stated as follows. The tribunal, and I quote, further retains that the convention has to be interpreted in the light of the rules set out in the Vienna Convention on the Law of Treaties of May 23rd, 1969, and that Article 31(3)(c) of that treaty indicates that account is to be taken of any relevant rules of international law applicable in the relation between the parties. The BIT cannot be interpreted and applied in a vacuum. The tribunal must certainly be mindful of the BIT's special purpose as a treaty promoting foreign investments, but it cannot do so without taking the relevant rules of international law into account. The BIT has to be construed in harmony with other rules of international law of which it forms part, including those relating to human rights. Now, this is a very forceful argument in an investor state arbitral award as to the integration into the interpretive process of relevant norms or relevant sources of international law. Furthermore, in the award in Tulip Real Estate Development, reference is made to the famous now International Law Commission study group, which rejected in its much discussed fragmentation report of 2006 any suggestion that international tribunals should completely restrict themselves to the treaty upon which their jurisdiction is based and which constitutes the treaty under dispute. Inversely, as many commentators have also forcefully argued, there are, of course, arguments against adopting a methodological approach in the interpretation of investment treaties that infuse externally standards of review not reasonably drawn from the text, object, or purpose of the treaty, even seeking inspiration from the normative framework laid down by the VCLT. Indeed, just to mention, as I have opined myself in a separate opinion in an important Grand Chamber judgment delivered by the Strasbourg Court, I said this: words matter when interpreting a legal text, including an international treaty. That proposition is the cornerstone of the fundamental interpretive principle provided for in Article 31 of the VCLT, which provides that the starting point is the good faith interpretation of the terms of the treaty in question in accordance with the ordinary meaning to be given to the terms in their context. As to relevant policy grounds, it is difficult to reasonably argue with the cogency of the claim that the interpretive assessment by arbitral tribunals in investor state cases should be strictly objective and based on the object, text, object, and purpose of a treaty or a particular treaty provision viewed in their context in accordance with Article 31, paragraph 1 of the VCLT. These are also the interpretive benchmarks under the ECHR. If one attempts to draw conclusions from the arbitral tribunals I mentioned above, such as Urbaser and Tulip Real Estate Development, it seems, however, that some arbitrators have considered that resolving cases lodged by private actors, including investors, seeking protection against unlawful regulatory measures imposed by a sovereign state will inevitably require an approach in determining the standards of review to be applied. Just as with investment treaties, the substantive provisions of the European Convention, as I mentioned, were silent for decades as to the nature and scope of such standards, albeit the margin of appreciation having been inserted in the preamble as of 1st August 2021. Therefore, it seems to be argued a strictly textualist and teleological approach within the four corners of an international treaty, which is silent on standards of review, will ultimately not suffice in constructing a principled framework of methodological analysis when it comes to reviewing state action, whether under investment treaties or the European Convention. So the argument is more conceptual work is needed to preempt legitimate criticism, the ones we're seeing now in the investor state field. I mention again the energy charter debate, couched in terms of lack of legal certainty and foreseeability with the respective dispute resolution mechanism, all values which lie at the core of the rule of law. Again, arbitrators are fundamental components of the international rule of law order. So therefore, the debate on standards of review needs to be an integral part of that debate. So to sum up this first part, I'm comfortable, I think, in concluding that the wholesale transposition of the ECHR doctrine of the margin of appreciation to the investment treaty field is neither justified as a matter of legal principle flowing from public international law, nor on policy grounds, as others have also argued convincingly. However, if one analyzes the development of arbitral practice and arguments drawn from the current state of public international law and policy, it does seem that this lively debate is justified and ongoing on whether a potential middle ground is legally justified. Such an approach would, it seems, entailing extrapolating, when appropriate, the core conceptual elements of the doctrine of the margin of appreciation and determining whether they can justifiably operate in a manner which promotes the underlying purposes and values of investment treaty law. Now, again, I think it is prudent, it seems to me, not to opine on the feasibility of such an approach in the abstract. It all depends on the text and structure of the investment treaty one is working on. But I would limit myself to hopefully contributing to informing this debate by explaining from my vantage point as a former Strasbourg judge and president of that court, how the margin of appreciation actually operates under the ECHR. It will then be for arbitrators and practitioners to make their considered assessment as to whether this framework of analysis is relevant for investor state cases. And I do that because, with all due respect, one tends to see in the investor state field that the use of the margin of appreciation is often lacking in rigor and maybe to some extent an acknowledgement, an understanding, an acute understanding of the underlying mechanics of this doctrine. So what are the conceptual elements? I think, and here one point that I would really like to stress, when one looks at commenting in the investor state field on the margin of appreciation, I want to make the point, it is insufficient to analyze the doctrine as applied under provisions of the conventions that do not implicate explicitly or implicitly the type of rights claimed by investors in arbitral proceedings when relying on provisions of investment treaties. Because to ascertain the core elements, the proper starting point is the Strasbourg Court's case law under Article 1 of Protocol 1, which protects a person's enjoyment of his or her possessions. You cannot be referring to the margin of appreciation, under Article 8 on the right to private life or Article 10 on freedom of expression. That's simply conceptually incorrect. That, however, is often what happens when commentators are reflecting on the doctrine of a margin of appreciation in other fields, like in investment treaty law. So I want to focus here on what is actually relevant. That is Article 1 of Protocol 1 and the way the margin of appreciation operates in that sphere of law. Now, when one analyzes the case law under Article 1 of Protocol 1, it is important to bear in mind that the way in which the doctrine of margin operates is not captured in its full extent by isolated references to the court granting states a wide, narrow, or certain margin of appreciation. This I often see in arbitral awards. It's sort of picked up almost wholesale as the starting point and the end point. This is not, I think, the right understanding of the way the margin of appreciation operates. Now, let me then explain what are the elements we should look to. The margin of appreciation under Article 1 of Protocol 1, and here it is different from other provisions of the convention, but in the property rights provision, is determined by three factors. First, the nature and scope of the public interest or governmental aim, which forms the basis of the interference or restriction of a property right interest, legitimate or expectation. Two, the nature and scope of the governmental measure that is the source of the alleged interference or restriction. And three, the extent or scope of the consequences that the measure has had on the property right interest or legitimate expectation claimed. Investor state lawyers, arbitrators, and counsel will recognize these three criteria readily. There's nothing new under the sun here. The operation of the margin in property rights cases thus requires a three-step analysis, which will determine the standard of the review in the case at hand. Therefore, the doctrine, the ECHR doctrine of the margin of appreciation, is not a fixed one-size-fits-all standard of review determined once and for all at the outset, but rather an ensemble of core conceptual elements that operate as gradations in the intensity of review throughout the process of adjudication, ultimately guiding the process through a step-by-step analysis to the ultimate substantive outcome. Now, very briefly then, under the first step of the analysis, the actual words, the margin of appreciation, are usually employed by the court to describe the overarching framework of deference, which then takes place in the second and third step. Here, the court is analyzing the nature and scope of the public interest or governmental aim pursued by the regulatory measure in question. It is clear that if the measure is considered to fall within the scope of economic and social policy, the court will consider the margin of appreciation to be wide. But this is the crucial point. This statement is limited to the question whether the aim pursued can be accepted as legitimate or more accurately in the public interest within the meaning of the convention. Thus, under the court's case law, the court will not find a violation of the convention on this first step unless the assessment by the government is manifestly without reasonable foundation. This is simple rational review, almost like arbitrariness review within investor treaty law. However, the salient point is that this high level of deference is limited to the first step of the margin of appreciation analysis. Here is where we have to be careful. It's not that a government comes and says, we are basing our measure on economic and social policy and the review mechanism is over. That's not what happens. Because if the court accepts under the first step that the aim pursued is legitimate, The second step of the analysis requires the determination of the level of deference, taking account of the two other criteria: the nature and scope of the governmental measure that is the source of the alleged interference or restrictions, and the consequences. Here, the court makes a crucial distinction between deprivation of possessions, in other words, expropriation, under the second sentence of the first paragraph, and control of use of property on the other. Whilst the court may, in the field of economic and social policy, find that the margin of appreciation is wide under the first step as being limited to the determination of the aim pursued, if the regulatory measure in question constitutes expropriation, then the margin of appreciation invariably becomes substantially more narrow under the second step of the analysis, triggering a form of strict scrutiny. And there is ample case law demonstrating that the stricter standard of review is then triggered under the second step. And therefore, when arbitrators are looking at this manifestation of language, the margin of appreciation is wide at the initial stage, we have to be careful. You cannot stop there, because then you have to look to the nature of the measure and make a determination on whether the review standard is then subject to an evolving stricter scrutiny throughout the process. The stricter standard of review under the second step would then trigger the court operationalizing its review based on its classical test of proportionality with 4 objective requirements. And these are quite clear and they are very systematic. 1, you look at the amount of compensation. Goes without saying, it's an expropriation. 2, you look at due process rights. 3, expeditiousness, stability, and coherence of the governmental measure. And 4, did an assessment by the government take place on whether less restrictive measures were envisaged or possible? Now, when it comes to applying this standard, it is very, very important that methodological rigor be applied, that it's sort of not an overall, very much a fluid type of reasoning, but a reasoning in the review process goes step by step through these elements. And I want to take you to a case which is an interesting one for these purposes, because it's a case that could have well been decided in arbitration, but was decided in my court. And it's a case called Vekoni versus Hungary of 2015. And I should disclose that I sat in this case myself in the panel of 7 judges. The applicant primarily alleged that the loss of his tobacco retail license by way of a statutory cancellation of all such licenses and their non-renewal had amounted to an unjustified deprivation of possession within the meaning of Article 1 of Protocol 1. The court did not accept that the statute in question canceling the applicant's license had amounted to expropriation, but rather that it constituted a measure of control of the use of property under the second paragraph of that provision. I will come to this differentiation of concepts a bit later. The court accepted that the government had enjoyed a wide margin of appreciation due to the general interest underlying the measure, which had been based on public health considerations and the nature and scope of the measure as constituting the control of use of property and not expropriation. Now, all of a sudden you might think, well, isn't the case over? There is a wide margin of appreciation at the first step. This is public health. It brings us to, the award in Philip Morris Brands. I mean, this is, arbitrators, judges were hands off. No, because even though we started off in this case on the basis of a wide margin of appreciation as to the public aim, we still had to go through the second and third steps. And there, if we looked at the third step in particular, the loss of the license reduced the applicant's business by 1/3 of its turnover, leading eventually to its winding up. And given the serious economic consequences flowing from the criticized measure, we concluded that this was a severe measure in the circumstances. Hence, the application of the quadridimensional 4 steps of the proportionality analysis. First, the license had been extinguished without compensation. So here again, and this is often a misunderstanding under ECHR case law, compensation, if not awarded, even though there is the issue is not one of deprivation of possessions, will be assessed under the proportionality analysis for the control of use. Secondly, the measure was not subject to any public scrutiny or legal remedy. Thirdly, the measure had been introduced by way of constant changes of the law and with remarkable hastiness. And fourthly, had not been alleviated by any positive measures on behalf of the state, violation of the property rights provision. So to sum up this part, the core conceptual elements of the doctrine of the margin of appreciation as applied in property cases. Again, I stress this point because this is crucial. Article 1 of Protocol 1 comprised a 3-step analysis and the formulation of the standard of review to be applied in a particular case to governmental measures interfering with property. Each step requires a fact-sensitive assessment in determining the intensity of review of such measures. The margin of appreciation thus constitutes a multi-layered framework of analysis where the proportionality test comprises 4 objective requirements that must be operationalized on the facts of each particular case. Let me now, before I conclude, say a few words about current arbitral practice referring to the margin of appreciation. Now, over the last 2 decades, a number of arbitral tribunals have relied upon formulations such as margin of appreciation, margin of discretion in their assessment of claims. Firstly, arbitral tribunals have resorted to the margin of appreciation at the preliminary interpretive stage of assessing whether a governmental measure constitutes deprivation of investment under BITs. I refer here to Saluk investments, or whether an expropriation has indeed occurred. And these are the awards in Continental Casualty Company and Investmart. This is a very different way of using the margin of appreciation to the one applied at Strasbourg. At Strasbourg, when an applicant says, my property, my investment has been expropriated, there is no margin of appreciation in that assessment. That's simply an objective, fact-based examination of the nature of the measure. It's not, whether the state has a margin of appreciation in that fact-based assessment. No. So there, I think that's a different way of using the margin of appreciation in investment treaty law, in these awards at least, than what would transpire from Strasbourg case law. In fact, Strasbourg case law is far stricter to the government here than would transpire from these awards. Ultimately, the margin of appreciation only comes into play when we are assessing the government's justifications for the measure it's taken, not its own identification of the measure as such. Secondly, one might ask, but is this because the investment treaty in question is worded in those terms? Now, for example, in Saluk Investments, the tribunal opined that Article 5 of the Netherlands Czech BIT was, I quote, drafted very broadly and did not contain any exceptions for the exercise of its regulatory power. The tribunal therefore interpreted the provision in the light of the general principles of customary international law that a state does not commit an expropriation when it adopts general regulations within its police powers. Hence, on this view, the core question in Saluka was a threshold question of the scope and content of the concept of deprivation and investment under Article 5 of the BIT, which they considered required a holistic examination already at that early stage of the analysis of whether the existence of lawful and permissive regulatory action aimed at the general welfare of the state, precluding a finding that the measure constituted a deprivation at all. Now, here I think, the question arises, do we take a more clearly objective view of the concept of deprivation, which I think is the interpretive, coherent way in investment treaty law, fully commensurate with Strasbourg law, Or do we have it a more fluid analysis encapsulating objective criteria, including also justificatory analysis by the government? This is open to question. As you can hear, I'm more inclined to take the more objective approach on this, maybe because of my experience in the Strasbourg court. I think it's more coherent. Secondly, it can be inferred from existing arbitral practice that tribunals have resorted in a similar manner to the way a case would be analyzed under the ECHR. Now, here we have Electrabel, Philip Morris Brands, which is probably the award with the most analysis on margin of appreciation due to the disagreement between the arbitrators, and Deutsche Telekom. In Electrabel, the interesting question for present purposes was the conformity of the governmental measure of regulated or administrating pricing with Article 10, Paragraph 1 of the Energy Charter Treaty. This is a very important piece of interest now for the current landscape. The tribunal found that Hungary would enjoy a reasonable margin of appreciation in taking such measures, being held to account under the ECT's standards of protection. Now, this is an argument that demonstrate that under the Energy Charter Treaty, arbitrators have indeed been able to balance the conflicting interests. As I mentioned, Philip Morris is probably the award in current investment treaty practice containing the most explicit elaboration. Now, in that case, it seems clear that the majorityist approach is similar to the Strasbourg Court's overall framework of analysis in affording a wide margin of appreciation when it comes to matters of public health. Now, that's, of course, not as such a surprising high threshold to start with. But again, I think when one analyzes the reasoning in more detail, it is clear that it is likely that if this case would have been litigated in Strasbourg, the challenge measure would have undergone a more systematic analysis within the context of the quadridimensional proportionality test and been subjected to an assessment under the 4 objective criteria. I think here there is a difference with the way the margin operated in Philip Morris vis-a-vis the way it potentially would have operated in Strasbourg. So finally, Deutsche Telekom, an interesting one. The tribunal was faced with having to examine an argument by the respondent government relying on its right to protect essential security interests within the meaning of the 1995 Germany-India BIT. First, it's finding that this provision of the BIT, as with similar provisions of other BITs, cannot be equated with customary international law defense of state of necessity, is noteworthy in the light of the current status of public international law. I'm going to allow myself to take no final position on this finding, but it is indeed of potential relevance for the wider array of current societal problems, including in the climate change field. I would finally just want to mention and turn to the tribunal's proportionality analysis in Deutsche Telekom. It focused, 1, on whether the measure in question was principally targeted to protect essential security interests at stake. 2, whether it was objectively required in order to achieve that protection. 3, whether the state had reasonable alternatives, less in conflict or more compliant with its international obligations. And finally, analyzed, 4thly, the import and intended effect of the annulment decisions. Now, the tribunal did not transpose wholesale the doctrine of the margin of appreciation into an analysis, but seemed to have proceeded on the basis of the particular elements flowing from Article 4 of the BIT. But there is an element of synergy here, which is interesting for the purposes of this lecture. So to sum up, before I conclude, I think it's firstly not the case that existing arbitral tribunals demonstrates that ECHR doctrine of the margin of appreciation has been as such transposed wholesale into the investment treaty field. I think far from it. But I would say that if the margin of appreciation or a margin of deference is pleaded by government in investor state cases, which is often the case, and maybe even will be increasingly so, it seems clear that arbitrators and counsel need the necessary tools to be capable of taking a considered view on the relevance of the actual correct operation of the margin of appreciation so as to not, to some extent, muddy the waters on how this potential doctrine can be applied. So allow me to conclude. Criticism leveled in recent years against the system and investor-state arbitration has at times been based on factual assumptions which have been proven to be incorrect. For example, the claim that investors win most investor-state cases. The current Secretary General, Meg Kinnear of ICSID, has made clear that this is erroneous. Simple statistics demonstrate that. But stakeholder perceptions remain, and perceptions, even empirically incorrect ones, are often difficult to countenance. Having been president of an international court within a multi-challenging international field and a geopolitical atmosphere of immense challenges to multilateralism, I can tell you, I know it is very difficult and it's crucial to maintain impartiality and the appearance of strict independence in applying the international rule of law. Whilst party autonomy, in particular the appointment of arbitrators and the choice of the applicable law, remain key components when applying the substantive law in question, the determination of contentious legal questions must preserve the foundational premise of preserving balance between investor rights and the host state's sovereign regulatory authority. If a host state has acted unlawfully in contravention of property rights under an investment treaty, compensation should unequivocally be granted. Inversely, if the state has acted in a manner which furthers a compelling interest and clearly fulfills other requirements under investment treaties for resorting to their police powers, the investor must potentially accept the harms to his or her investment which follows. Let's not forget, this flows from the nature of the concept of investment. One of the criteria is there an element of risk? There is always an element of risk in any investment. So let me conclude, ladies and gentlemen. In this year's Kaplan lecture, for which I again thank my good friend Neil and the organizers for inviting me to deliver, I have firstly tried to demonstrate that the wholesale transposition of the doctrine of the margin of appreciation to the investment treaty field is not as such justified as a matter of principle. Secondly, I've hopefully managed to contribute to this debate by reflecting on the arguments for and against the relevance of some of the conceptual elements of the doctrine for investor-state arbitration, and in particular by explaining from my vantage point as the former president of the Strasbourg Court how the doctrine actually operates in the ECHR system. I hope that my contribution can inform the work of arbitrators, counsel, and investment treaty scholars in the difficult and challenging times ahead. Thank you very much indeed.
Thank you very much. That was fascinating. There is a question from Paolo Frolin. Is the doctrine of the margin of appreciation found in any non-European conventions similar to the way that it has been incorporated into the European Convention on Human Rights?
I think my answer to that is I'm not aware that it is. And actually, it would be strange to some extent if one would find that kind of review standard directly explicitly mentioned in these conventions. What one would have to look at is certain language in the newer human rights conventions, like the Inter-American system, the African system, and so forth. But if you look at, for example, the ICCPR, the 1966 conventions, you will not find these kinds of direct, explicit manifestations in the text of the convention to the doctrine. And I think the reason for that is the one I tried to explain. This is a methodological tool. It is a review standard which review powers, judges, adjudicators, arbitrators, employ in a fact-specific examination of claims being made by governmental powers in their use of their powers in restricting rights. So then an arbitrator, a judge, whomever is deciding a case like that, will have to ask a threshold question, which is this: what is my position vis-a-vis the dispute and the underlying claims being made by the parties as to the distribution of powers in their juridical relationship. And of course, arbitrators are often, especially investor-state arbitrators, are of course far removed from the actual fact-specific situation on the ground. And arbitrators are not, by definition, they will not be citizens of the state in question, that is the defendant government. They will not necessarily have a background in the actual or historical knowledge of the fact-specific situation in question. So therefore, like an international judge in the Strasbourg court, in the inter-American system, in other systems, that is a threshold question of the existence of review standards that one basically by definition has to answer when one goes through the process of deciding a case like that. And that's why I think, and this is my final point as to that question, methodology and rigor in methodology is crucial. It is so crucial that you go step by step through an assessment of the review standard, because the more inconsistent and incoherent to some extent the review standard, the risk there is that outcomes will not be internally consistent. In any system based on the rule of law, that is a problem.
Early on in the lecture, you said that the margin of appreciation has now been inserted into the preamble. Can you remind us of the wording to how that was done?
So it's done by a simple reference in the preamble on the basis that the states recognize the principle of subsidiarity and the margin of appreciation as being an integral part of the system. Now, what the attempt is here to do is the margin of appreciation is something that the states have, and this goes back to a process under the convention which started in 2010-11. It's called the interlochen process. It was a review of the whole system. And that system was based on states wanting the future of the convention to bring more balance between individual rights and the public interest. It's very interesting, Neil, because a lot of what happened in the beginning of the last decade in the convention system is exactly what we're seeing in ISDS. It's the same kind of underlying debate on the need for investor-state arbitration to be one where the arguments adduced are managed, operated, or assessed in a balanced manner.
You were drafting a treaty. How would you, investment treaty, how would you encapsulate that doctrine? And would investors go for it?
Well, I think, what I think would be useful, would the investors go for it? That's a good question. The salient point that I would like to make is that, is it better for an investor who is deciding on whether to invest in a host state on the basis of protections afforded in a BIT, for the BIT to be absolutely silent as to the review standard, giving full flexibility and uncertainty as to how a governmental measure restricting their investment would be assessed by arbitrators? Or would it be better overall, on balance, that the treaty itself tries to tie down the criteria for any eventual proportionality assessment or any assessment of a measure, which would give the investor and the state a possibility to objectively argue for the existence or non-existence of those criteria? Because I think it's ultimately a fallacy to believe that silence on the review standard will, in the long run, be more beneficial to the investor than the opposite. That I think is something, I think that's an idea we need to reflect upon. So my answer would be, if we would be now formulating novel BITs, which many states, as you know, and many we are doing now, taking into account issues of sustainability and business and human rights principles and so forth. And of course, the whole energy charter debate is really about this. Then I think it would, be something to look at whether that particular type of analysis, textual analysis, should be performed. Yes.
I mean, in relation to expropriation, you've got the limiting factor there, public purpose, right? What more would you need for expropriation? I mean, we all know what expropriation is. They can prove it's for a public purpose, or they paid compensation, then the state's off the hook. Otherwise, there's a claim. What more would you need to do in relation to expropriation of one of the claims?
I mean, my question would be, public purpose is, and this is exactly the same analysis performed under Article 1 or Protocol 1. The question arises, the invocation by government of the measure being for a public purpose, how do you assess that? How do you assess the cogency of that public purpose? How do you assess the nexus between that public purpose and the harm that it causes to the investment? How do you assess the factual underpinnings for the realization of that public purpose? What are the steps you take in making a considered assessment of the nexus between a claim for expropriation having been made down and the government's defense? That requires a standard of review. It requires an adjudicator, an arbitrator, to lay down the methodological analysis for that.
As has been done in some cases.
Absolutely, yes.
Spiros, do you have a question or two?
Point to make. I don't have a question actually, but the point I want to make deals really with your insights, Neil, in terms of choosing the right speaker at the right time. I think you have contributed immensely with this series of lectures, and choosing the right person at the right time in terms of career developments and how they can contribute to how the law develops is brilliant. I want to thank Robert because this was an excellent lecture, and he managed to take something that appears to be detailed, focused, but married it very well with investment treaty, human rights under the rule of law umbrella. And I want to highlight 2 points. One, at some point he mentioned that words matter, and words do matter. And what he did, turning the detail into a big picture that conceptualizes what he wanted to cover and contextualized it brilliantly, looking at the longer term relationship when you are dealing with an investment is critical. This is not something that you have to consider against the context of a particular dispute. You have to think about the future. You have to think about how you maintain your market when you're investing in something. And he did that exceptionally well. He also mentioned the importance of looking at these issues with rigor. He has contributed a lot, immensely, in his role as a judge. And I think it's a huge opportunity for him to apply the same rigor as a practitioner. And I'm looking forward to the jurisprudence that he will contribute to developing from the other side. I think his insights will be powerful, very useful. But also his rigor would be very much welcomed. So I think he will have a lot to contribute. So I want to thank you, Neil, for your insight and your forward thinking when we're looking at choosing the right speaker. I want to thank Robert for his excellent lecture. I think it was one of the best lectures that I have attended in this field, and I'm very proud that the British Institute of International Comparative Law contributes to supporting this lecture. And also want to thank the Hong Kong International Arbitration Center, HKIIC, for organizing this lecture without any glitch. They were very good dealing with all three of us. I'm looking forward to see the published version of this lecture. So thank you, Robert, and thank you all for attending. That was a brilliant lecture.
Thank you very much, Spiros. That's extremely kind of you. Indeed, I think what we are seeing in international law, public international investment treaty law, is the importance of synergies across field, at least for us to be able to have a discussion about these various issues. That is the way we move forward, I think.
Yeah, and the point you make that parties would be happy to have some sort of delineation of how they resolve these disputes is critical. It helps both sides.
Yes, exactly.
There's another question, Neil.
I can't see it. Can you?
Yeah, the question is, if the doctrine of the margin of appreciation is not considered by arbitrators in investment treaty arbitration, do you see states withdrawing from investment treaties in the same way they have left the Energy Charter Treaty, as we discussed earlier? And this is a question from James Calderwood. I think it deals with the bigger issues that's
I thank James for posing that question. I mean, I think, yes, I think this is potentially the elephant in the room. Well, it's not even an elephant. We all recognize this. I wouldn't pose the question in terms of, you know, the margin of appreciation as such as the only salient issue. I would simply say that moving forward, investor-state arbitration is one, both from the investor side. And I want to highlight this because it's often mentioned that, you know, to some extent, any discussion about the two sides and an increased realization that there are two parties to this, and that we have to keep, and I say we, the community of, in the field of international arbitration and international law, we have to keep the stakeholders on both sides believing in the system. I mean, the system, and this is the same that I had to grapple with as president of the Strasbourg Court for years. I mean, if the states, if the government stakeholders stop believing in the system, ultimately everyone loses. So therefore, I do think, and this is why I provocatively call this lecture a new frontier, it's not really a new frontier because the issues we're dealing with have been there for a long time. But I think it's a new frontier because the pressures on the system from the stakeholders is increasing. And we cannot just, you know, disregard the kinds of reactions we are seeing by states to the Energy Charter Treaty or other forms of multilateral trade cooperation. And this means that arbitrators, counsel, and I would even say the investor community need to be mindful of that starting point, because ultimately the investment must be protected. That's clear. But the government, on the other hand, must be able to accept overall that the benefits of the system is one that outweighs the potential limitations that the system will have on their ability to impact investment. And that means that ultimately the system needs to introduce a rigorous view of how that relationship is encapsulated in the adjudicative process. And I think moving forward, I'm very interested in taking part in that debate and work in the future.
Let me just ask you one last question, which we should have touched on before, perhaps. What are your views about an investment court rather than the arbitration system?
We have discussed this, Neil, you and I, and I have the vantage point of having presided an international court, which is a permanent international institution staffed by elected judges. Currently, multilateralism, the idea of standing international courts having an impact deciding on the relationship between individuals and governments is under great challenge. It works in the field of human rights because of its long genesis, its long history. If we were now today to come up with the idea of the European Court of Human Rights, which would have binding authority under international law to decide on violations of states, we wouldn't even get in the door. I mean, that would simply not be an option in the current landscape. So this gives you a flavor of my view. I think when it comes to a multilateral investment court, where states would have to accept, and on the flip side, investors would have to accept, that those kinds of monetary disputes would be decided by standing international judges, where the flexibility of the arbitral system, the ability to have knowledge picked for the dispute, to be able to have a flexibility in the procedural mechanics of the system, which is adapted to the applicable, the dispute in question, the choice of the applicable law. In my view, that's not the problem. The problem is not that the arbitral system is not one as such at its core that can bring to a conclusion in a very robust and a rule of law oriented way the issue in question. The issue is rather that the way the system is developing when it comes to methodological analysis is one, like any other system, needs to adapt to changing circumstances and the nature of the way we understand the underlying treaty and purposes of investment treaties. So I'm hesitant. It's maybe something one would need to reflect upon further, but at this point, and here, as I said, I have the vantage point of actually having been an international judge for under a decade. I'm not sure the answer to the problem is going to reside in creating another international institution to decide those issues. It's better, I think, to have this debate and start from the ground up within the current system and be open to reforming it from within so it can be sustainable for the future.
Thank you very much. Well, Spiros, I look forward to entering discussions with you to try and find next year's lecturer who can live up to the standard that we've just had this year.
Thank you for the challenge, Robert.
Robert,
thank you very much indeed, and to all that
thanks.
participated.
And I'm sure we all wish you very well with your new career. It's a good age to start a new career, and I'm sure you'll be a great success. And we look forward to hearing more from you and reading more written by you on these interesting questions. Thank you very much for your time and for the very interesting lecture.
Thank you very much indeed.
And thank you everybody for joining up and listening. I hope you're still there. I think a copy of it will be available for people to read at their leisure. So thank you all again for attending, and I wish you all seasonal greetings. It's almost that time of the year. It's December the 1st tomorrow. Summer in Australia. So good night, everybody. Thanks.
Good night.
Bye.
Thank you. Bye.